for him this morning because Mr. Etherly wasn't there. I haven't even had an opportunity to discuss this with Mr. Etherly, so he's finding all this out right now. But they issued a K piece for him because he wasn't in court on the state's motion. So we're going to file a motion this afternoon to set that aside. We're going to file a motion. I'm going to file a motion to dismiss the whole case. And I'm going to ask that the court look at the video and see what I've seen. So we'll see what happens there. But we still have that harassment, which I don't know if the grand jury will indict him or not. It might get no true bill. I don't know how the state's going to proceed on that. I understand that Mr. Etherly has caused members of the community to be offended. I understand that. But that's not a factor in raising bail. And that's not a justification to hold him for effectively without bail. We have sources here today. I have, not in addition to the Give, Send, Go money that's been raised. There's a gentleman back here named Alex Rosen who makes a lot of money online doing a pretty noble thing. He has this show or podcast or whatever you call it these days called Poaching Predators, I think it's called.
Predator Poachers.
Predator Poachers. So, and he makes about 6 figures a month. And from what my discussions with Mr. Rosen, his efforts have led to the arrest of some 90 different suspected pedophiles this year alone. So, totally legit source of income. He's willing to post the bail. But the order from Judge Poland said we're not allowed to use the Give, Send, Go money. There's about $300,000 there, so we could post that bail there also. And there's been rumors circulating all about this online. There is some owners of a casino called Duel who want to post his bail also. I can't probably get that approved by this court, but they're a foreign corporation, Judge, and I can't get the person here to testify. However, I believe they're working with Mr. Leverson's bonding company to put $1 million in his account so that he has the collateral should Mr. Etherly fail to appear, the whole collateral. And that's in addition to Mr. Leverson's insurance fund that he has. So Mr. Leverson's asking he'd be allowed to post the bail, or post the bond, I guess I should say. We would join in that motion. We have somebody who can pay Mr. Leverson the full $100,000. He has $500,000 in his account right now. If Your Honor would approve that source, I can put him on the stand if need be. I don't think the state necessarily opposes him as a source. I don't want to speak for General Nash, but I mean, we have everything ready to go to do this. Nashville threw a wrench in the plans this morning, but we'll still have to deal with that. But Your Honor, we have everything ready to get this gentleman bailed out. Now, I did ask that bail be lowered, and I would still request the court take that into account and lower it. $1 million for a shooting where someone's not dead. That's a lot. That's a lot. And I understand Judge Poland saying, hey, he's out on bail for other things. But let's look closely at what these other things are. I mean, these are petty, petty crimes. Even if they were true, could result in a diversion. Nothing that's, and they're not, frankly, they're just ridiculous allegations. So I would ask the court to take all this into account and to reduce his bail accordingly and allow Mr. Leverson to post his bail, whatever the court thinks is appropriate. And I can put proof on, if the court needs that. I have Mr. Etherly's father here and Mr. Rosen here to testify. And we have a whole row of folks in support of Mr. Etherly here as well, which again, that shows he has ties to this community.
Just respond, Mr. Nash.
Briefly, Judge. Bond was set at $500,000 on the new case, and then doubled according to 40-11-148 that says the court shall set the bail twice the amount when someone's on bond. It says shall. So Judge Poland followed the law as he saw it and as it's written. There's been a lot of narratives about what the proof is. I have the warrants from Nashville. I have the warrant from here. The harassment case here is private prosecutor. There was a preliminary hearing, and I believe it was bound up. So, despite what Mr. Finley says about the merits, it is in the system. It is going to the grand jury. The Nashville case, theft of services, he went to a restaurant, ordered a lot of food. He was doing his streaming at the table and in the restaurant. They asked him a couple of times to stop. He refused. They asked him to leave because of that. He said, well, I'm not going to pay if you're going to make me leave. So a little bit different facts. And, of course, on the way out, he's dropping all kinds of negative words at everybody, and that was the basis of the disorderly conduct and, I think, the resisting arrest. So that'll be played out in Davidson County. if somebody can make bail, I think the only thing Mr. Finley needs to hear is what is the court's requirement, how many bonding companies and so forth, and what would be the conditions from this court, according to the law, for Mr. Finley and any third parties that want to post bond for Mr. Etherly. I don't know where, it seems like that's what he needs to know from the court, if he has people that can make the $1 million or any other way through a bonding company or companies that the court requires. You know, while we're here, but the facts of the matter of this particular case here, given Mr. Etherly's business venture, which is Chud the Builder, is live streaming certain interactions with black people, saying derogatory things. We know what that is, causing an interaction and a response from certain black people on the street. Been doing it for probably close to a year now. That's his stated purpose. So he goes out to intentionally incite and provoke black people for a response. And that's what he did on May 13th here. No legitimate purpose for being at the courthouse that day. He had missed court at 9 o'clock. This is all proof that came out in the preliminary hearing. A default judgment was taken in a civil matter. Mr. Fox, however, was here on a child support matter with his wife to begin at 1:30.
Who was here?
Mr. Fox.
Who?
Mr. Fox, he's the person who shot 5 times. He's the alleged victim in this case. We have tracked through video the exact moments that all parties arrived on the courthouse campus. Mr. Fox and his wife arrived about 1:08 from North 3rd Street and proceed to go to the main entrance and just sit on those concrete planters. Mr. Etherly probably makes it to the parking lot about 1:12, starts walking across, that's on the North 2nd Street side, starts walking across, selfie stick in hand, immediately walks right in front of Mr. and Mrs. Fox, and now we don't have audio yet of it, but he stops right at Mr. and Mrs. Fox, and what can only be assumed is starts his live streaming right there. The same thing he does, approaches the first black people he could see. That happens for maybe a minute right there. Mr. Etherly walks away, selfie stick in his right hand. He's still looking back at Mr. Fox over here. Mr. Fox is looking at him. Mr. Fox does get up and approach Mr. Etherly.
Yeah. Where does this interaction take place?
Right on, it's closer to the North 3rd Street side of the courthouse, as you're walking out the courthouse, looking at the historic courthouse.
Right, but it's on the courthouse property.
Oh, yes, yes.
How far away from the plaza, for lack of a better description? The plaza being that planted area.
Well, it was right, it had, all this occurred right at the last set of planters
Okay.
on the left-hand side. Mr. Fox is seen in the video making gestures to Mr. Etherly. Mr. Etherly switches his selfie stick to the left hand. He puts his right hand in his suit pocket. This is prior to any physical interaction. Mr. Fox walks away from him. He comes back. Mr. Etherly is trying to reach something out of his pocket. Just common sense says it's the firearm because he has the selfie stick in his left hand. And then Mr. Fox strikes him as the gun comes out. 7 shots are fired within seconds. 5 of them, I believe, struck Mr. Fox as they went to the ground fighting. That is the case. Like I said at the prelim, some of these are going to be splitting hairs. Some of this law about self-defense, the proportionality of a punch compared to using deadly force, whether there was provocation that negates a self-defense claim, all those things happen later. But some of these things showing just some 404B stuff, motive and intent. He has posted things on X, made other videos on X on what his intent is. For instance, on May 4th of this year on X, he posted, "Keep encouraging your fellow blacks to assault me. When you see a chimp with their brains blown out on the timeline, just know y'all did this to your own people." May 7, 2016, this is 6 days before this event. Chud the Builder posts on X, "I will defend my life with lethal force. Do not approach me with intent to threaten bodily harm." And then he posts another response to himself. "Series finale is dead chimp on the pavement and you monkeys rioting when I walk free. Stay tuned." That's just one that shows his motive and intent on what his business model is. Does it rise to provocation when he then takes to the street and interacts with black people to get a response? Could very easily be provocation, which negates any self-defense, or the proportionality of the force used by Mr. Etherly to a punch in the face. He uses deadly force. Mr. Etherly has to reasonably believe of imminent danger of death or serious bodily injury in that confrontation with Mrs. Fox. So there are legal aspects to the reasons why this was done and the actions my office took. So, and those were all the things that were argued. I think the bond is reasonable. Whether the court wants to put down requirements and conditions on how a bond would be made, I think that would serve Mr. Finley better. Thank you.
Mr. Finley, you look like you want to say something.
Well, that's sometimes one of my biggest problems, Judge. I always want to say something. Now, it was hard to go through everything that happened at that prelim. Mr. Nash, or General Nash, excuse me, not Mr. General Nash, brought up some points that I just want to clarify. It was Investigator Libertor, maybe Sergeant Libertor now, who said he was going through the social media and he testified and put these posts in that General Nash was talking about. Now, these posts weren't done in a vacuum. These posts were part of back and forths between Mr. Etherly and several other folks, many of which were making threatening remarks to him. So saying he can defend his life with, or that I'll defend my life with lethal force is the right of every American. Everybody in this country has the right to do that. Everybody in the world ought to have the right to do that. So, and then the riot response, while offensive, was also done in response to threats to him. I believe the post he was responding to was something about the other season finales. Mr. Etherly, a gunshot wound to the head, dead, or something to that effect. So he just gave back what he was getting, essentially. Now, he's been streaming for about 6 months, Judge. I understand he's a white man saying racially bad things that upset typical folks. I get that. But he still has his First Amendment. And regardless of whether it's offensive by the general population, he has to be allowed to speak when he wants to speak, unless it breaks a law. It's not illegal yet to say those things. It might be illegal in Great Britain, but it's not illegal here. And I was just talking with my father earlier today about Socrates. When he began to criticize democracy in Athens, they decided to kill him, one of the greatest minds in history. And now, I don't care if he says offensive things. The whole world can be mad at him all they want to, but we can't prosecute him for that. And we can't hold him to a different standard for that. He's still an American citizen. He has the right to say whatever he wants to say. Some certain exceptions, mind you. But he hasn't done anything like that. And whatever was said to Mr. Fox by Mr. Etherly doesn't warrant a physical attack. That's not what the fighting words doctrine means. The fighting word doctrine limits civil liability if somebody says some horrible things to you. Self-defense does not contemplate words. Mr. Fox had no legal justification for striking Mr. Etherly, and he struck him in the back of the head. And if we are able to get the proof from, wherever on the internet, we're hoping we can get it from, we're still early in the game, but I believe the proof is going to show that Mr. Etherly didn't say anything racially charged until Mr. Fox started threatening to kill him. And then he's struck by somebody who's a self-proclaimed combat veteran, who says he was having a PTSD episode. That's for a jury to decide, but there is a strong self-defense here. Proportionality is going to be a question for the jury to decide. But we have a man who was attacked, and he responded with force, lethal force. That's unquestionable. That's in the video. but he was attacked first. He was approached after he walked away. There's no legal provocation that justifies Mr. Fox's behavior. So, with that in mind, we do have sources ready to go. Your Honor, just tell me what we need to do.
All right, I'll tell you, at this point, let's address the bond issue. Obviously, the General Sessions Court had an opportunity to spend, half a day listening to proof, I assume, viewing some videos. And I think it's pretty much agreed that there was confrontation here, but even in its best light, it's a situation where an individual had a gun and a fist fight. And I don't care how good you are with your fist, most time that doesn't work too well for the fellow with the fist if he's going to beat up against the gun. Secondly, the General Sessions Court took under consideration the fact that Mr. Etherly was out on bond. And I understand, they may be weak cases, but the law provides that the bond is to be doubled. And the reason for that, if you've been arrested on bond, there's kind of a warning that maybe you need to, shall we say, conduct yourself perhaps in a different fashion from what you would otherwise. I mean, I think the thing and the reason I asked about where this altercation took place, one of the issues, and where the Montgomery County Courthouse is somewhat different from courthouses, painted on the front door, each of the doors to the Montgomery County Criminal Justice Center, as well as the historic building, the historic courthouse, is the code section saying no firearms are allowed on the premises. Which is interpreting no firearms allowed in the building. Understand, this took place outside the building. It took place in this evidence that was considered in the General Sessions Court, and which apparently is stipulated here, that this incident occurred right outside the door of the courthouse as a result of an individual possessing a firearm which he had walked maybe 20 feet. You couldn't have it. So, and I understand, Mr. Finley, maybe the cases are weak, but there's a basis there for the bond to be done. Now, that brings us to the point of the amount, the initial $500,000. Judge Poland, again, spent half a day listening to the proof and made his decision, and given again, the history and considering the bond factor, I can't take issue with that. And I think one of the interesting things under State v. Burgess, which is kind of a Tennessee case dealing with bail at 464 Southwest 3rd, page 298, was probably one of the best decisions Tennessee-wise dealing with bail. Recognize that under both the federal and state constitution, there is a right to bail. But quoting from the decision, we hold that a defendant's constitutional right to pretrial bail is subject to forfeiture, and in this instance, the forfeited the bail. And the court went on to find that it is not a right without restrictions. Understand there's a First Amendment right. We kind of all learned in law school, First Amendment right doesn't give one the right to yield fire in a crowded theater. And that's an issue that would be dealt with at trial. With that said, I'm going to leave the bond the same set by Judge Poland, except there's going to be, I reviewed the General Sessions order, and I do not believe there was any curfew in place.
No.
I'm a big believer in curfews. An additional item, additional aspect of the bond set in sessions is that the defendant and the accused will be subject to and does he do anything other than post on social media? At some point in it, I read it's Chud the Builder, and I have to assume that he does construction work.
Your Honor, he does have a construction company. I believe most of his focus nowadays are on his online presence, but he, before he started posting, he ended up losing a construction job over some incidents, and that kind of led him into where we are today. So, but then he started his own business. So he does have his own business, but he's primarily a streamer, I guess would be the word.
Well, you know, maybe that one such a good career choice. But in any event, be subject to a curfew from 9 p.m. to 5 a.m. He's got to be in his house, and what's his address?
I'd rather put that under seal if it pleases the board.
We got to know where to look. It's going to be wearing a GPS, and I want to know if he's not where he's supposed to be.
Understood. Because of the attention, he's about to be evicted, so I can
Find
provide.
out where he's going to be living, and next time, you have to have that address. He's been required to stay at that address from 9 p.m. to 5 a.m.
Understood.
All right, now, that condition would also be applied then to the bond on the harassment, which will lead to some. Now, we have to address the source here, correct?
Yeah.
You wish to address that at this point?
Call Alex Rosen.
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir.
Would you state and spell your name for Madam Court, or Madam Court Reporters, I should say?
Yes, Alex, A-L-E-X, and last name is Rosen, R-O-S-E-N.
Thank you, Mr. Rosen. Mayor, pass the witness a couple of stacks of documents.
I think something needs to be on the record.
Yes, sir.
I noticed your T-shirt.
Yes, sir.
You go to school there?
No, sir, I travel the country for work, so I just accumulate college T-shirts, but I'm not college educated.
That's my alma mater.
Nice.
Just want everybody to go on the front end. And, that's where I went to college, Sanford University, Wyland, Alabama. I say all the time. All right, you may proceed.
Thank you, Judge. Mr. Rosen, I passed you a few stacks of documents. Can you tell the court what those are?
Yes, sir. So this document right here would be currently what's in my savings account on my Bank of America banking app. That is who I bank with. And then this right here, if you were to scroll through the pages, would be my Cash App statements that, for the most part, get deposited into this bank account.
Okay. And you've got a lot of these, particularly transactions with Stripe.
Yes, sir.
In your Bank of America. Would you please tell the court what that is? What is Stripe?
So Stripe is like a payment processor. So what we do for work is we have a group, we catch online child. Oh, okay, sorry. We have a group, we catch online child predators across the country called Predator Poachers. And I'm from Houston, Texas, but we've been to all 50 states. We've helped get arrests pretty close to here, like in Rutherford County and Cheatham County, I think is how you say. So we've been literally all over the place. And yeah, so I've been doing this for 7 years since I was 19 years old. I'm 26 years old now, and I employ 20 people. And we do post our interactions online. It's similar to Chris Hansen's To Catch a Predator. And obviously what you post online will get pretty censored a lot of the time. So we have a website called locals.com where you can post basically the uncensored interactions where you don't have to bleep out choice words or graphic things that the predators might have said to the assumed child. So on Locals, people sign up. They pay a small subscription fee every month. And we have about 17,000, give or take, paying members on there right now, paying anywhere from $5 to $10 a month. So obviously, over the years, that's accumulated, and we've certainly been blessed with the work we've put in.
So when you have this $2,300 deposit from Stripe, that's just your membership fees, or?
Yeah, so people sign up throughout the month. So, for example, people that have signed up, let's just say on, what's today's date? June 3rd. So if they signed up like on May 3rd of this year, they get charged on May 3rd, and then they get charged on June 3rd. So basically, we get statements throughout the month based on when people signed up.
Okay. So all of these Stripe transactions are from this website and legitimately earned income?
Yes, Stripe would be either from that locals.com, and we do have an X page with about 490,000 followers, and we make probably a couple thousand a month from there as well, and that's also for Stripe.
Okay. Your Honor, I'd like to move that into evidence if the court would accept it.
That being,
The Bank of America page and all of the Stripe transactions company.
Bank of America page, it's right transaction to be marked, it is collected exhibit 4 for this year.
Yep. Stripe would be super.
Yeah, hand back the, this one. Hand it back on the back.
Yeah, so cash app's on the
Yeah.
right. Stripe would be on the left past Bank of America, like in that stack.
Well, I'll ask the Cash App statement be made exhibit next, but let's talk about it first. Ms. Loach, you ready? Okay. So you also have a Cash App bunch of pages, like some 30 pages or something to that effect.
Yes, sir.
And that has just money in, money out. You got 48,000 and some change in Cash App transactions. How did you get these transactions?
So we live stream our interactions a lot on kick.com, and similar to Chud the Builder, it's offensive. It's just offensive to pedophiles rather than a certain race of people. And when people watch our stuff, they might get, we do advertise my Cash App, so people give us Cash Apps throughout the week or month or whatever. So if somebody sees like what they think would be a good Predator Cash or whatever, they might contribute on Cash App accordingly if they feel in the giving mood. And I also do pay my employees on Cash App, some of them. I do have a lot of people under 1099s that are like contractors for me. And yeah, people just support on Cash App, and that's just another source of income for us.
Okay. I'd like to make that the next exhibit, please, Judge.
Witness's Cash App statement to be marked as exhibit 2.
All of this income you earn legitimately and you pay taxes on it.
Yes.
Pass the witness.
Mr. Rosen?
Yes, sir.
If I can hold up, this, it says business advantage. I think you've identified this
Right.
as your savings account.
Yeah, so basically it's a preferred savings account. So essentially, because of a certain amount of money I had in there, I think it's over 100K. Bank of America told me I was doing like some car note or something like that. They gave me the option to go meet with some advisor there, and he advised me to put the money into a preferred savings account. So that account that you see the 500,000 in, that would just be the preferred deposit account. So I could move that on any weekday during business hours.
Yeah, I'm just, is this your personal funds or is it under
Personal.
a business?
That's my personal account.
Okay, personal account, okay. Thank you. And the one that has the transactions listed, is this going into your personal checking account?
Yes, those do get deposited in there as well.
So you don't have a business account for anything you do?
No, sir. I just hire contractors under a 1099.
This is all money coming directly to your bank account through a Cash App?
So there would be some money going in, some money going out. So if you go through the transactions, you'll see I'm paying people as well. But I believe we received 48,000 on Cash App in the past month. I could be wrong, but if that's what it says, that's what I would have received.
Well, you say we, and what I'm trying to get to is, this is your personal accounts, not a business venture account.
That's correct. Yes, sir. So it would be on, yeah.
How much is in your savings today?
It would be around the same amount, give or take. I took that screenshot yesterday.
$500,000?
About so.
Thank you, sir.
Yes, sir.
Where do you live?
Houston, Texas.
And people give you money because you're chasing child predators.
Yes, sir.
And how do you find out if somebody's a child predator?
So we essentially set up accounts online posing as children or people interested in children. And it's sadly very easy to find them. I mean, I wouldn't even say we find them, they find us. They message the account under the assumption that we're a child, and we notify them of our age. And then based on certain state laws, if we feel they break them, because in most states, the state laws, if they believe they're talking to a child, it's prosecutable. In Tennessee, it doesn't necessarily say that, but in Tennessee, there's a criminal attempt statute that's been applied to our cases in order to kind of circumvent the solicitation statute. And they essentially just solicit who they believe to be these kids for sex. And obviously, we're not using real kids either. A lot of people decoying as the kids are older than I am. But yeah, we set up meetings, or they set up the meetings, and very often they show up at a location, and we interview them on camera in hopes to get more evidence, and then we call the cops. And in the past 2 days alone, we've assisted in 4 arrests across Texas.
People give you money to do it.
So there's not necessarily like, we get this much if this happens. People just choose to contribute on their own free will, but yes, people seem to like what we do.
And what are you proposing to do as far as Mr. Evans is concerned?
So I'm hoping to bond him out. You know, I myself am a free speech absolutist, and yeah, I just don't think he should be in jail right now.
So you're gonna turn this, you're gonna write a check, however much, not a check, you're gonna turn over X number of dollars to the circuit court clerk.
I'm going to pay the bondsman.
He intends to pay the bonding company.
Right.
$100,000.
Yes, sir.
All right, anything else?
No, sir.
All right, you missed that.
That is one potential source. The other source being Mr. Dalton's own funds that he's crowdsourced himself. Again, Your Honor, he has almost $300,000. I tendered those documents to the court. Judge Poland did say you can't use any money that was gained after the shooting, the May 13th date. I respectfully disagree with that ruling. I don't know any legal basis for the court to say he can't use crowdsourced money himself. However, we do have Mr. Rosen here in the event that the court decides that Judge Poland was correct. I just don't know what the precedent would be to say Mr. Etherly can't use his own crowdsourced money.
Okay, now, you also representing, L.A. Bonding?
I don't think I can do that in this situation. I think that's too close to a conflict. But Mr. Leverson is present, and he has, I believe, submitted to the court proof of his own insurance policy, which would cover $1 million. Of course, Mr. Leverson's here; he can speak for himself. But we would join in on the motion if that would make sense, because it definitely benefits Mr. Etherly. So, Mr. Leverson has the capacity to make this bail, and he has the insurance backing to cover it if Mr. Etherly didn't show up. I don't think we're going to have an issue with Mr. Etherly not showing up. I believe Mr. Etherly is looking forward to his day in court.
I was on materials filed at L.A. Bonding, make a reference to a legal law transfer from dual.com. You know anything about that?
And I know somewhat some things about that. There was an attempt from Dual to send Mr. Leverson $1 million in funds. There was some kind of flag that a bank put on those fundings. And then the individual owner, or one of the owners of Dual, I'm not exactly sure how that's all structured, but one of the owners of Dual is wanting to send him that collateral personally. So I believe that's in transit as we speak. But again, between the insurance and Dual's actual cash money that Mr. Leverson will be holding, there's the $1 million right there in full.
Well, I understand that a little closer about dual.com. As I understand, I think I read this on the island of autonomous to some country in the Indian Ocean.
That might be where they have been incorporated. They also have another corporation that manages Dual that is incorporated in Panama. Not that that really helps the court very much. But again, that's more of a security for Mr. Leverson and his company at this juncture. We have the capacity to post the bond. So that would just, I hope, put any fears to rest from the court that if Mr. Etherly did show, that there wouldn't be funds to come to the county. I mean, county
I just want to know where this $1 million is.
a lot of gambling folks. A lot of folks like to gamble.
It's actually an illegal activity in Tennessee.
But it's not in Armenia, which I think is where they.
It's illegal. Technically, if I'm using my computer, using your platform, and I'm in Tennessee.
Yes, sir. I hope Tennessee changes that one day because I like
I know,
poker
but they
games,
ain't
but
yet.
not yet. But I believe even a casino in Tunica or Vegas could come in here and, pay bail money and things like that if they wanted to. I don't think we'd consider it to be tainted by criminal activity.
Because it's legal in Tunica.
Yes, sir. And what we're doing with that whole statute anyways is we're trying to seize drug funds. I mean, we're trying to keep drug money from being in the community. I mean, that's the whole purpose of that chapter.
All right. Any other proof?
No, sir. Not on the source.
Okay, I guess we've also got a motion that's tied with this by, I guess, L.A. Bonding.
Yes, sir.
Do they wish to be heard at this point?
I don't know if the court will accept my argument. Mr. Leverson, I think, would rest on what I've said. He joined in my, he's back here, of course.
Is that right, Mr. Levinson?
Yes, Your Honor.
I stand wish to present proof this matter.
Now, the source here.
All right, I think we've got, all right, now, here's kind of where we are. Bond's gonna stay the same. Additional curfew restrictions as to the bond situation. It's been the practice of this court and continues to be so that it would be, under our local rules, courts have to approve any bond, like, technically, any bond over $75,000, any one bond company. Traditionally, my practice to not go over $100,000. It's going to continue to be my practice. I understand that LA bond was backed by an insurance company. I do find it somewhat peculiar. As I look at the materials, it looks like the $1 million, quite frankly, it's not clear whether the $1 million is being transferred to the surety company to, I guess, keep LA bonding in good graces and keep their capacity where it needs to be to write other bonds, or, but for whatever reason, I am, that source troubles me. So I'm gonna leave the restriction in place. Any bonding company can be limited to 100,000, translates into 10 bonding companies to make a $1 million bond.
You want to prepare this order?
You prepared to order? Any other issues we need to address?
I guess you accept Mr. Rosen as appropriate source, correct, based on his testimony?
He divided up among 5 bonding companies. I mean, I'm not gonna let him get in the bonding business.
Okay.
And let's be clear, it wasn't, I'm not real clear that Mr. Rosen's getting ready to clean out his $500,000 savings account, write a check to Wendy Davis, clerk of the circuit court in Montgomery County. I mean, it's up to him.
Thank you.
Now, let me say, Mr. Finley, I understand that, if all these other cases go away, the current opinion in Davidson County, maybe we'll need to revisit the issue of law. Any other issues we need to address in this case?
Not for the state, Judge.
Ms. Finley?
Your Honor, there was a motion filed to ask for return of his truck and other personal property. I don't know if the sheriff is, I would assume they're done processing that at this juncture.
We are.
Okay, if you're prepared to then, as far as the pickup truck and other personal property.
Yes, sir.
Probably need to itemize things that you want in addition to the pickup truck. I don't know if there's other items.
Your Honor, my position would be that everything needs to be returned that was in the truck to Mr. Etherly, unless it's specifically marked and being held as evidence. I
Okay.
understand there's two.
Let's, one thing.
I have some information.
All right.
The county took the info system out of the truck to download it. So I don't think it's operational without it.
Oh, the black box.
Yeah. So
The
I'm gonna check.
They're actually EDRs.
That's correct. So I'm gonna check with the county, reinstall that piece, but the state has no further use with the truck.
Were there any, my understanding was that there was a ticket or application for a ticket in the pickup truck.
I think, yeah, it's a printout of that itinerary for Mr. Etherly, and we have seized that and the bulletproof vest.
I assume they did not have the truck.
Those two, they're in county possession as
All right,
evidence.
that's why I'm saying we need to make sure that we itemize the items to be returned so there's no misunderstanding.
Yes, Judge.
There's a difference between a pickup truck and a bulletproof vest.
I agree. And I'm not asking if they want to use that as evidence. I understand that.
I mean, that's a 404 issue.
Right, and that's not on today. I don't know that I can itemize everything that's in his truck. I don't know if we can itemize everything that's in his truck, but can we just say everything in his truck minus what's been seized as evidence, and then the state can just tell us what they've seized? I mean, I didn't know they ripped the black box out of his truck till just now, so,
Well, you don't rip out a black box, you just take it and extract it.
well, you're more eloquent than I at times,
Well,
Judge, I'll give you that. But, I mean, so that was news to us, but I mean, we'd want everything returned if it's not being seized as evidence, is what I'm asking.
I'm sure the sheriff's office will do an inventory.
All right, let's do an inventory, you need to itemize things that you want to keep.
Yes, sir.
All right.
Thank you.
All right, any other issues we need to address?
Not from the state, Judge.
All right, Mr. Nash, if you're prepared to.
Yes, sir.
And Mr. Finley, please, please.
Yes, sir. Thank you.
Last thing, Your Honor, there might be 20 bonding companies in this county, and it's my understanding that maybe one or two are willing to do business with us. Is there any way the court would consider raising the amount of money that one bonding company can operate? I mean, 10 different bonding companies is onerous. It's very, very difficult for us to get 10 bonding companies to do business with Mr. Etherly.
That's a Pandora's box that I'm not gonna answer your, I mean, that's a policy that has been followed for some time. In fact, I think I actually increased the amount for my purposes.
I think it was 50 before, and you raised it to 75.
No, actually, that, quite frankly, it's practical, I've raised it to 100, clearly, I mean, as long as bonding company's got that capacity, we should not do it. All right?
Thank you. Thank you. That would be a good time to ask about resetting the talkings. I believe that was on the afternoon docket. Or that may have been.
Okay, 1 second, please, recommended on that report, totally, that's what All right, Finley, you got a motion